Well, good afternoon, everybody. Can everybody hear me okay? Is that good? All right, well, thank you for having me today, and I appreciate being asked to come talk again. I'll just quickly tell you, just real briefly, about my work history so you kind of see how I got to where I am in this title insurance world. But when I graduated from law school, I went to work for a law firm, and we handled title insurance claims. And so my background is primarily real estate litigation and handling title insurance claims. So I've seen everything that goes wrong in a real estate closing and tried to fix it on the back end. But about 6 years ago, I took a job with First American in-house as underwriting counsel. And so now I handle underwriting questions. So what that means, day to day, I field questions from law firms, closing attorneys, closing staff about title issues. So this is on my title. Do I need to worry about it? Is this an issue? How do I fix it? If I need to fix it, what do I do? So I have a little bit of unique experience in that I've kind of seen both sides. I'm now the underwriting side, and I have experience in the claim side. So I've seen what we can do to avoid problems and then what we can do to fix them. So today we're going to specifically talk just about title insurance and what it is. And I will say, and I say this every time I do this because I do a lot of trainings for our office, title insurance is maybe not the most exciting thing. I think it's interesting, but it's not the most exciting. So I really want this to be informal and be a discussion. If I start talking about something and it's words you haven't heard or concepts you don't understand, just jump in and interrupt me. I mean, I promise you don't want to sit here for 45 or so minutes and listen to me talk about title insurance. So there's no stupid questions. If something doesn't make sense, just interrupt me and let's talk about it and discuss it. So what we'll do today is look at title insurance. What is it? What does it do? What are the different kinds of policies? What do those policies cover? What's not covered by the policy? And then after we talk about that, we'll look at some real world examples, some actual claims that the company's gotten, because I think I can explain title insurance all day, but it doesn't necessarily click until you hear some real world cases. And here's what happened, here was the problem, here's why it was covered by the policy. Because as you're working towards closings, you may very well get questions from buyers, from lenders about, what does the policy do? Why is it important? Why is title insurance important? So I think it's helpful to see some practical, real world scenarios so you can see what it does. So what is title insurance? I think everybody understands auto insurance, property insurance, because that's something we all deal with on a day-to-day basis. But title insurance is a little bit of a different animal. So it's a contract of indemnity. And what that means is title insurance doesn't guarantee that the title to the property is perfect. It's not a warranty of title. It's not a guarantee that there's no title issues. But what it is a contract of indemnity that says if there is a title problem and it's covered by the policy, it'll pay the insured for any loss they sustain because of that title defect. So it doesn't guarantee there's nothing out there, doesn't guarantee flawless title, but it provides insurance against a loss that's sustained because of a title issue. Unlike other types of insurance, title insurance goes backwards. So title insurance insures against past problems. There's a few post-policy coverages, and we'll look at that in a minute, but for the most part, title insurance looks backwards. So it insures against things that have already happened before you're closing. So auto insurance insures against future risk. It insures against something happening down the road. Your property insurance insures against something happening to the house down the road. Title insurance is different, it looks backwards. And the other distinction with title insurance is that it's a one-time premium. So the buyer pays a premium at closing, pays a premium for the lender if there's a lender at closing. Once that premium's paid, it's done. That policy's in place. So it's not a monthly premium, it's not an annual premium, it's a one-time premium at closing. So there are two basic types of title insurance policies. There's an owner's policy and a loan policy. And I don't know, that's probably kind of little. I don't know if you can read it up there, but the owner's policy insures the property owner against loss that may be incurred as a result of a number of things. So that would be the policy that your buyer would buy at closing. That's the owner's policy. So maybe the seller didn't have the right to sell the property to that buyer. Maybe the seller forged the deed. That would be something that the owner's policy would cover. The owner's policy can be issued to a single person. It can be issued to a number of people. If there are two people, husband and wife, father, son, buying property together. It can even be issued to an entity. So if a corporation or an LLC is buying property, anybody that can legally hold title to real estate can buy an owner's policy. The loan policy, it works a little different. So the loan policy insures someone, typically a bank, a lender, who has taken a loan or has given a loan that's secured by real property. So it also insures against loss as a result of a number of title defects, but sometimes those things are different. So maybe two owners own the property and only one of them signs the mortgage. That would be an example of something that would be covered by the loan policy, because again, the loan policy relates to the lender, the insured security deed. The owner's policy relates to the owner's interest in the property. There are different types of owner's policy and loan policies. For purposes of what we're going to do today, we're not going to look real specifically about every single nut and bolt involved in these policies, but just so you're familiar and aware, there is a standard owner's title policy, and in what we call at First American, the Eagle owner's policy. Different companies have different branded names for that policy. That's an enhanced coverage policy. And then there are three types of loan policies. So just your standard, basic, some people call it long form loan policy. There's a short form loan policy, and if you know anything about residential property or you do residential closings, that's typically what's used in a residential transaction. And then the enhanced coverage loan policy, which we call the Eagle loan policy. So for our purposes today, we're really just going to look briefly at the standard owner's policy and the standard or long form loan policy. So some of you may be very familiar with the title insurance policy. Some of you may never have seen it before. So the title insurance policy is made up of a jacket, a Schedule A, and a Schedule B. There's a different type of jacket depending on what policy you're issuing, but it's not going to vary for that type of policy. So no matter what your transaction is, if you're issuing a standard owner's policy, the jacket's always going to look the same. If you're issuing a short form loan policy, that jacket is always going to look the same. It's pre-printed information that's not anything specific to that transaction, it's just the policy jacket. And that policy jacket sets out various terms for the policy. So it's going to have your covered risks. That's a list of all of the items that are covered by the policy. It's going to have the exclusions from coverage, which is everything that's not covered by the policy. And then it's going to have conditions. And we'll talk a little bit more detail about these, but it's going to have conditions. Those are just some terms that explain how the policy works. So that stuff is always the same. Doesn't matter about the transaction. It's always going to be the same. And then, so you have the policy jacket, then you have your Schedule A. That's going to be sort of what I call the information page that explains, that sets out the information about the transaction. So it's going to have the insured's name, description of the land, the amount of coverage, the amount of insurance, everything that's specific to that transaction. So jacket, then your information page, your Schedule A. And then you have Schedule B, which is where you'll find all of the exceptions from coverage or the things that the policy does not cover. One other thing, and if you've done some real estate, you may be aware of this, but there are also endorsements that can be issued to the policy. I'm not going to talk about those specifically today, really, but just be aware that you can also add endorsements to the policy, and they add coverages or modify coverages that are already in the policy. So, what does title insurance cover? As I said, the jacket sets out the various covered risks. There are a good number of them that are the same for the owner's policy and the loan policy. So I thought it might be helpful if we just walk through and talk about some of those, just so you can see what kinds of things are covered by the policy. So the first covered risk is what we call vesting. Both policies insure against a loss if title is vested other than is shown on Schedule A or on our information page. So an example would be, let's say the policy shows titles vested in ABC Inc. But when your examiner runs title, they determine that there's actually an old missing interest in the chain, or maybe the property was titled in a related entity, DEF Inc. or something, some other entity's name. that's an example of something that this covered risk would cover. Another example would be, let's say, two people inherit property, and we'll actually look at a claim about this, but two people inherit property, two sisters, and down the road, one of them sells the property. So the policy might show title was vested in your new owner having come from those two people, but only one of them signed. So you've got a missing interest. So title is not really currently vested, as you think, because we have a sister in the back chain that still owns an interest. So does that make sense? Just anything showing that the property is vested other than Schedule A reflects. The second one is title defects and encumbrances. And this is sort of an all-encompassing. Lots of different title defects would fall under this covered risk. But some of them would be forgery, fraud, incompetence. Maybe somebody signed a document in the back chain and they weren't competent to do that. Maybe one of the deeds in the chain or even the vesting deed isn't properly attested. You know, it hasn't been signed in front of a notary, which is required in Georgia. Maybe there's a missing witness on a document. We see a lot of powers of attorney these days. Nobody really likes to come to closing anymore. Everybody's busy, so they give power of attorney. But sometimes those aren't used correctly, or sometimes they're expired. That would be an example of a title defect that would be covered. Maybe there's something that just wasn't filed or indexed properly in the land record. So lots of different title matters would fall under this. But those are some examples of title defects that would be covered under that covered risk. Another would be marketable title. I don't know if you've heard that term yet, but marketable title in the title insurance world is a little different than you might think of marketable title just in the real estate world in general. So you might think of a marketable property as in a good school district, or the house is in good condition and the landscaping is really nice. Those are things that make a property marketable so a buyer would be interested in it, but marketable title for title insurance is a little different. So title insurance ensures the buyer that the seller had the interest in the property and had the right to convey that interest. So just a little different way to think about marketable title than from a true real, normal real estate perspective. That's the marketable title. Another covered risk is access. So property needs to abut a public road. Title insurance policy ensures that you have legal access to your property. One thing to think about there is it doesn't ensure, and it does, and the enhanced coverage policy does, what we'll look at later, but the standard policy doesn't ensure that that access is actually feasible. So it ensures that the property touches a public road, but it doesn't ensure that you can drive a car from that public road onto the property. It might be rough terrain where you can't get through, or it might be some kind of swampland or something, but it ensures that your property touches a public road, not necessarily that it's true physical access to the property. Is all this kind of making sense? Okay. The next one sounds very convoluted. Government regulation described in recorded notice. What the heck does that mean? There are a lot of governmental regulations that affect the property that aren't necessarily covered by title insurance, but this would be something that's actually recorded in the public records. It's like an eminent domain taking, where the government took property. So if somewhere in the back chain the government took some property for a right-of-way or for eminent domain, that's something that would be covered by this covered risk. Another is title being vested other than as stated. We've already talked about the vesting covered risk. This one's a little bit different. So this one insures against loss sustained if title is vested other than shown on that Schedule A information page because of some sort of fraudulent or preferential transfer. That's, I would say, the bulk of title insurance claims probably come under vesting or access or title defects. That one's not as common. Another covered risk is gap coverage. I don't know if that's something that you've talked about already in here, what we call the gap in title insurance or in real estate. So if you sit at a closing and your buyer and seller sign all the paperwork, there is some time before everything actually gets recorded. So the time between closing and when everything gets recorded, that's the gap. That's what we've referred to as the gap. And as you can imagine, it's possible something else gets recorded in that gap ahead of your deed or the security deed signed at closing. And so it's really important, particularly to lenders, that they have what we call gap coverage. So the policy does say that it ensures the time between closing and when everything gets recorded. And I don't know if you have discussed this already or if you maybe have just seen it on the news, but during COVID, we had a lot of clerk's offices that shut down. They would have positive COVID cases and they would close for 14 days to clean. Well, especially if that clerk's office doesn't e-record, there would be a decent sized gap where nothing was getting recorded. And so that became a really important thing, particularly to lenders during COVID, that the policies covered the gap. So you may get questions about that. We get questions about it a lot of times from closing staff where the lender wants to make sure there's gap coverage. That's what they're talking about, and that's covered by the policy. And then finally is creditors' rights. This is kind of another complicated one, but this provides some coverage for transfers that are a preferential transfer under bankruptcy. So if you hear the term creditors' rights, that's a bankruptcy issue. So those are your basic covered risks that are included in your owner's policy and your loan policy. So primarily, title defects, vesting being a big one. Vesting is as shown in Schedule A, and access, I would say, are probably the biggest ones that come up. Those are included in the owner's and the loan policy. The loan policy has 4 additional covered risks, and those all relate to the insured mortgage, which is the lien on the property. So these cover things like invalidity of the lien, again, forgery, something like that for whoever signed the security deed, lack of priority, forgery, something not the security deed not being properly signed, not being properly witnessed or attested. There's also coverage for lack of priority of the lien. So if there is another security deed that never was canceled, or there was a judgment against the seller that didn't get paid, those things would all be recorded ahead of the security deed from your closing and would be ahead of it in priority. So yeah.
So we had actually saw a clip where this woman's house got tore down and sold because they forged her deed and said that she sold it. So if she had title insurance, would that be something that would have been covered because somebody forged her deed?
So if somebody forged the signature on the deed into her?
No, saying that she had sold.
Oh, they said, it could be under the enhanced coverage policy, which we'll talk about in a minute. A standard policy, no, because that standard policy cuts off at the date of recording. You remember it goes backwards?
Yeah, that's what I was
Yeah, but an enhanced coverage policy, it could. That provides some post-policy forgery coverage.
Okay.
Yeah, so it could be there. That's a great question.
You wouldn't really think to buy in advance, right?
Well,
in that case,
yeah.
Wait, what?
I will say that especially in Georgia, the enhanced coverage policy is a lot more common than the standard policy. It has a higher premium because of that.
Much real estate fraud.
And yeah, and especially now that stuff's turning over. I don't know. I mean, I moved here 6 years ago, and it was very much the trend then. I moved here from Mississippi, where people did not buy that policy. It's more expensive. It wasn't as common, but in most parts of Georgia, I would say that it's much more common to see an enhanced coverage policy than a standard policy.
Someone did say that we're the worst state for fraud.
Yeah, real estate fraud.
Yeah, but that's
All the scams.
Yeah.
What's an average price difference between, are we talking another couple thousand, couple hundred?
Oh,
or
I
just
can look the
totally
numbers up.
different?
The policies are priced dollars per thousand, and so it's a higher dollar per thousand. I can look it up
Gotcha.
when we take a break or
Just
something.
curious.
I'll be like, yeah, I'll be happy to look at it. It's well worth it, the difference, I will
Gotcha.
say.
you
But it does cost a little more because there's a lot more coverage. Yeah. And so, yeah, so we were looking at the loan policy, the additional loan policy coverages. There's also coverage for the lender for mechanics liens, things that come up in construction of property. That's a big issue if you haven't already discussed that. Just contractors having lien rights if they're not paid against the property. And let's see, there's also some coverage for the assignment of the security deed and that covered risk. One thing that's interesting is when do claims come up? And there's a distinction there somewhat between the owners and the loan policy, because most loan policy claims don't come up until there's a foreclosure. Because if you think about it, as long as you're regularly paying your mortgage, there's really no reason for your lender to run title and find out that there's a problem, unless there's a foreclosure of something else that's out there, something like that. But most loan policy claims come in at the time of foreclosure. Most owners' policy claims come in just when they discover that there's a defect. So a little bit of distinction there. And going to your question, we'll look a little bit, and we won't talk about all of these in detail, but there is the enhanced coverage policy that provides the additional coverage, like what we talked about. And what this policy was developed to do was cover some of the practical issues that everybody thought was covered by title insurance and everybody thought should be covered in title insurance. So there was actually an enhanced policy developed to cover those things. And so some of those coverages are post-policy forgery, post-policy encroachments, things being built over property lines, post-policy adverse possession. So an example of that would be maybe you buy a property and it has a driveway on it that goes back to your neighbor's lot. And they just has a dirt area that they cut across to get to your neighbor's lot. Well, what if they come back 5 years after you buy the house and say, oh, I have an easement there. I've always used that. I have an easement there. That's an example of a post-policy adverse possession claim that there may be coverage for. A post-policy building permit and zoning violations. I mean, there's some expanded coverage for that, and there's some expanded access coverage. So remember I told you title insurance ensures that you have access to a road, that you touch a public road. The enhanced coverage policy gives you coverage for expanded access for vehicular or pedestrian access. So it says not only do you touch a public road, but you can't actually drive to it or you can't actually walk to it. So that's an additional coverage that policy gives. Some other ones, and again, we won't talk about all these in detail for the time we have today, but some subdivision violations, some restrictive covenant violations, some additional coverage under a trust if property's held in a trust, and there's some protection up to a certain amount for encroachments of your property onto a neighbor's lot, or maybe a fence going onto their property, encroaching onto an easement, things like that. So those are some coverages that are not in the standard policy. The enhanced policy, just so you're aware, it does have some deductibles. The normal standard title insurance policy, you pay the premium and you're done. Some of those enhanced coverages have a deductible, and some of them have a maximum payout, and that's all in the policy itself. You can see all that, but if you ever get that question. And then this policy, this provision is in all of the policies, and having been a claims attorney, I will tell you, I think this is probably the greatest benefit of title insurance, is that it has this attorney fee provision. So you can see, I won't read it to you, but you can see that this policy, this provision sets out that the company will pay costs and attorney's fees defending any matter insured by this policy. So it doesn't have to be a claim with merit. If someone sues you over something relating to your title and you have title insurance and it's something that would be covered, the company pays your defense costs.
Because going back to like that situation, like she ended up being tied up.
Yeah,
courts with that,
exactly,
so.
exactly. Well, and you may get in a dispute with your neighbor over something and they sue you. I will tell you, those things can go on for years and be very expensive. And so,
over 2 inches of
right,
thin.
exactly. I have tried cases based on things that are that small. So, and you can imagine what it costs to get a case all the way to trial. So, yeah, I always say I think that's probably the biggest benefit of title insurance, is that it'll pay to defend you if you get sued.
And that's whether it's standard or enhanced? Okay.
Yeah, that provision is in all the policies in the jacket. So we've looked at some of the things that are covered by the policy, all of the covered risks. The next thing in the jacket is the exclusions from coverage. So again, these are the same in every transaction. It's pre-printed in the policy jacket. It doesn't depend on what your transaction is, who's buying anything. These are just pre-printed in the jacket, but these are the things that aren't covered by the policy. So for the standard policy, matters that attach or are created after the date of policy. Again, title insurance goes backwards. So typically, unless you have an enhanced coverage policy, things after the policy are not covered. Things that the insured is responsible for. So the policy doesn't cover something that the buyer does. And a good example to think of for that is, let's say your seller has a mortgage and the buyer agrees to assume that mortgage. Well, they can't then file a claim and say, well, there's a mortgage on my property. Well, they're responsible for that. It's called created, suffered, or assumed. They knew it was out there. They assumed the mortgage. There's no coverage for that. And you would be surprised, but I field a lot of the general calls that come into our office, and I got a call one day from a lady who was very upset because her property was being sold at tax sale and she had title insurance. And the longer I talked to her, I realized her property was going to tax sale because she did not pay her taxes. And that sounds silly, but she really thought that was covered by her policy. It doesn't cover things that you're responsible for. So you're responsible for paying your taxes. Your policy doesn't cover that for you. There's an exclusion for matters known by the insurer, not known by the insurer, but known by the insured. So if the buyer buys the property and they know the seller and they know the seller has a mortgage out there that's just recorded in the wrong place, or for whatever reason didn't get recorded, there's no way we would know that because it's not of record, but the insured knows about it. So it doesn't cover things that the insured is aware of that the company would have no way of knowing. The policy doesn't cover if there's no loss. So you can think about it, there may be a number of title defects, and part of my job is to look at title defects and determine if we'll take the risk to insure over them or not. But if there's not a loss, there's no real claim under the policy. So there may be, and we get these calls sometimes because owners discover these things, so there may be a judgment out there that was against a prior owner. So yes, it's technically on title. But if nobody's trying to enforce that judgment, there's no loss. So there's no claim. The owner really doesn't have a claim just because the judgment's out there, they haven't suffered a loss. Because again, remember, we're not ensuring that your title's perfect. We're just saying we'll indemnify you if there's a loss for something on your title. And then just like the loan policy has additional coverages, it has a few additional exclusions that aren't in the owner's policy. Their jacket's just different because they're things that relate to the insured mortgage. All right, so we've looked at the coverages, all of the things that are covered by the policy. We've looked at the exclusions, so those are the things that are never covered by the policy. The last thing in the jacket is just the conditions, and this is sort of the things that explain how the policy works. So there's a definition section, just defines terms in the policy. There's a continuation of insurance provision, and what that does is explains when your coverage may continue even after you've sold the property. So typically your policy is in place until you sell the property. There are actually some things that can come up and come back on you after you sell, and your coverage continues for some of those. So there's a provision that explains how that continuation works. There are notice provisions, how to notify the company if you're aware of a claim or if you have a claim or if you get sued. And then there are some conditions that explain how the company will defend and pay claims and how all that works. So just explains how the actual policy works. So that's everything in the jacket. The first thing is, after the jacket, is Schedule A. And again, that's what we explained is the information page. So it's going to have all of the relevant information about your specific transaction. This is where if you're completing a policy, you would put in your transaction information. So it has the name of the insured, the amount of insurance, the date of the policy, how title's vested, the land. If it's a loan policy, there's going to be a description of the insured mortgage. Just everything about your transaction, all the information about your transaction. So jacket, Schedule A, Schedule B. Schedule B is the exceptions. So we've already talked about everything the policy covers, everything it never covers. Schedule B exceptions are the specific things about your transaction that won't be covered. So you would take your title, review your title, and we'll look at some of this in a minute, but things that will not be covered by the policy for your specific transaction are added on Schedule B. So Schedule B comes pre-printed with certain exceptions that apply to every transaction. And the first is taxes or assessments that are not shown by the public record. So taxes that are due that aren't a lien on the property, those aren't going to be covered. Things that you could find if you did an inspection of the property aren't covered. Easements, liens, or encumbrances that aren't in the public records are typically not covered by the policy. We talked about in a circumstance where that could be covered by the EGLE policy, but the standard policy accepts coverage for any kind of easement that's not out there because there's no way we would know about it. Next is what people call the survey exception. So encroachments, things that would show up on a survey are not covered by the policy. Mineral rights, and this is a bigger issue in certain parts of Georgia than other parts of Georgia, but minerals, people, lots of old deeds reserve mineral rights because people would own and sell the minerals. Mineral rights aren't covered by the policy. And then finally, the current year's taxes aren't covered by the policy because they may not be paid at closing, they may not be due till after closing. So there's always an exception, and you'll see on the policy you put the current year in, but there's always an exception for the current year's taxes. So these matters are what we call the standard exceptions. They're accepted in every policy. And then after that, you would add in anything that you see on your title. So if you were going to fill out the policy, you would review your title, review your commitment, and determine the things that weren't going to be resolved at your closing those would carry over onto Schedule B as special exceptions in your transaction. So if your property had an easement running across it, you would add an exception for that easement. If there was a lien that was not going to be paid at closing, maybe the buyer was assuming the seller's mortgage like we talked about, that would be shown as an exception. If there's a survey of the property and it shows that the house is built 3 feet onto the neighbor's property, that would be a survey matter that you would add. So anything specific to your transaction gets added onto Schedule B as an exception. Okay, so what does any of what I just said mean? Because that's all good information about what the policy covers and what it doesn't cover, but it's a lot more helpful to look at actual real life claims and see why they would or would not be covered. So let's look at the first one. I don't know if you can read that, but it says, what happens if someone else owns an interest in your title and that person's interest is not listed as an exception on the policy? So in this claim, the insured owner, the buyer, bought a very expensive beach house that actually sat across 2 lots. And you can imagine it's sitting on the beach. This was very valuable property, and it's sitting on 2 lots. Well, what they discovered when these ladies showed up and demanded payment was way back in the chain, 2 ladies had inherited title to one of those lots. Well, for whatever reason, somewhere down the line, probably the tax assessor, it was combined into one parcel, and so nobody ever caught that the whole chain was only conveying 1 lot. Well, as you can imagine, that's a big problem because half of the house is sitting on somebody else's property, and it was the property that those 2 ladies owned. So the insured filed a claim on the policy, and do you think there was coverage for that? Well, let's think about it. So
that's something that happened prior.
Right, it's something that happened prior. So the owner's policy would have shown that title to both of those lots was vested in their name, but it wasn't because those 2 ladies had title to that other lot. So that would be covered by the policy. It's covered risk 1, where we talked about vesting, where title is shown on Schedule A. Title's vested other than is shown on Schedule A. So their policy on Schedule A showed their name as the owner of both of those lots, and they didn't own one of those lots. So that's covered by that covered risk, and First American negotiated with those ladies and purchased out their interest in that second lot for a substantial sum of money.
So whose fault would that have been to have not caught that way back? Who's making the mistake on that?
Yeah, it could be any number of people. It could be the title examiner didn't catch it. It could be that it was on the title search and the closing office reviewed the title search and just never caught it. And it was pretty far back in the chain, so the last 2 or 3 maybe conveyances conveyed both lots. So if all you looked at was the vesting deed into the prior owner, it looked like they owned both lots. But if you traced farther back, our typical searches in Georgia go back 50 years. And so if you had looked back several deeds back, you would have realized that all that was conveyed out was that other lot, that there was never a conveyance of that other lot. So yeah, it was an expensive mistake. So let's look at the second example.
And whoever built that house got a deal.
Yeah. Yeah.
That's true.
I mean,
That's true.
dang.
Yeah, that's true.
2 lots for the price of 1.
So what if we discovered, going back to me here. What if we discover that there was forgery, fraud, duress, incompetency, incapacity, or an impersonation?
It would have to be an enhanced.
Well, maybe. Let's look at it. So here were the facts. So a couple decides to buy their dream home. They're going to spend their retirement golden years in this dream home. And they go to the bank and take out a loan to pay to construct the home. They did not buy an owner's policy when they bought the property. So they bought the lot, they went and took out a construction loan, but they didn't buy a policy when they bought the lot. So after they build their $350,000 home, they discover when the true owner shows up that the person who sold them that lot forged the deed. And we actually see this not all the time, but I've seen it in some properties in Atlanta on the Beltline. What happens is somebody who is a criminal sees a very valuable lot, and I saw this actual case on the Beltline. Obviously it's a vacant lot, nobody's living there, and they just come in and purport to be the seller. And that's what happened here. They talked these people into buying this lot. They didn't own it. I mean, they didn't have any connection to it. People bought the lot, borrowed $350,000. So the deed into that owner was forged, but they signed the mortgage to the lender. So when the true owner showed up and filed a claim, do you think there was coverage?
No.
There's no coverage for the owner because they didn't buy a policy. But what about the lender? There would have been coverage for the lender because there was forgery in the execution. But the problem was this owner still had to pay the bank, but they didn't own the house. So there was some negotiation to clear it up for the lender, but the owner did not have coverage for that. So you can imagine what would happen if they bought that lot and paid cash to build their house on it.
Mm-hmm.
They were just out that money, and they had no, they would have spent the rest of their retirement money probably would have been spent to pay off the owner to get that lot.
Are criminals in that circumstance, were they like prosecuted?
I don't know the criminal. Yeah, I don't know what happened with them in that one, but.
And they're just taking advantage really of the general public's ignorance on.
Yeah, and I got a frantic call one day on a property, I think it was on the Beltline, from a closing firm that said they had a lot under contract and they had just gotten a call because it was interesting. It was a vacant lot. The owner had died years ago and her estate was never probated. So there was nothing in the probate records to show any conveyance out of her. But they had a property under contract, and someone had called their office that morning and said, I just drove by, grandma's lot that's now worth a ton of money, and there's a for sale sign out front.
Wow.
And we're not selling it. Who's selling it? Well, somebody had come forward purporting to be the heirs. They had gotten an affidavit saying that they were the heir, and they listed the property. I mean, it sounds crazy, but this is the kind of stuff that happens. So that's one very good reason why you always want to buy an owner's policy. So if they had a policy, it would have been covered under that covered risk too, which insures against loss or damage from a forgery or a fraud or an impersonation. But unfortunately for them, they didn't have one. So this next example, what happens if there is a lien on your title because of a mortgage, judgment, tax or special assessment, or a charge by an HOA that wasn't shown as an exception on the policy? So in this claim, the owner was trying to sell a lot that they had bought 2 years ago. And at the time of that purchase, they did not buy an owner's policy. Well, when they went to sell the lot 2 years later, the attorney that was handling that sale found a judgment for $80,000 against the prior owner that was just missed when they bought the lot. So the judgment was not old enough to have expired. It was $80,000. So they called the law firm that handled their closing from when they bought the lot. That lawyer was out of business and disbarred. So there's no E&O coverage under the lawyer's insurance. So what do? They've got an open judgment for $80,000 against their property, and they don't have an owner's policy. They don't have any coverage. They had to go negotiate with that judgment holder because once they go try to sell the property, nobody's going to insure that transaction with an $80,000 judgment. They've got to clear it before they can sell that lot. And so they were out whatever they paid for the lot, and they were out the $80,000, whatever they paid the judgment holder on the $80,000 judgment.
Would that outcome have been different if the attorney was still in business and had the E&O?
Probably, because it was missed. Either he missed it or his examiner missed it, and I don't know which. But there would have been some recovery back against his E&O likely.
So
for
choosing your
that.
attorney for closing is even more.
Right. Yeah, it's important to pick someone. Yeah, it's important to go to someone that is careful and thorough and reviews the title.
Some longevity
How
in
often
the
does
industry.
this kind of stuff happen? Like, how many times a month?
I don't see the claims as they come in, but I will tell you we get a lot of claims. I mean, I could get the number. We get a lot of claims. And then, they're not always things like this.
Yeah,
but I mean, this kind of stuff does happen. Yeah. Right, this kind of stuff does happen. So if this owner had a policy, it would have been covered because it was a defect, lien, or encumbrance against their title. At the very least, the closing attorney should have caught it and cleared it. But if he didn't, and he just truly missed it, it wouldn't have been an exception on their policy, and they would have had coverage for it. But because they didn't buy a policy, they were out whatever they had to pay off that judgment. So what happens if a fraudster takes advantage of a typo. So in this claim, the fraudster filed, the property was owned by 123 Property Owner Group LLC, Property Owner Groups LLC. So we'll say it was owned by the entity with the S. You'll see the parentheses around the S. It was owned by 123 Property Groups LLC. And the fraudster goes to the Secretary of State and they file the paperwork to form an LLC called 123 Property Owner Group LLC with no S. And we've seen this claim happen in our office. Come into our office. So the fraudster then markets the property. It's a vacant lot, and a lot of times these things happen on vacant lots because nobody's living in them. Nobody, it's not a house that you're coming with a realtor to look at. Right? It's just a vacant lot. Nobody's really, you walk out and look at it, but you're not looking at a house. There's not somebody on the property to catch these things. So the fraudster markets the property, markets the lot, gets it under contract, comes to the closing with an operating agreement, a certificate of formation, all the things that you would need to show for an LLC. And the closing attorney doesn't catch that all his paperwork is missing the S. Remember, the property is titled in Groups LLC. So the investor buys the property, rehabs the property, and then all of a sudden, the investor comes by at one point to check on it, and there's somebody out there claiming to own the property. These things happen, and an investor drives by to check on his property and goes, "There's a house being built on my property. What's happening here?" So the property had been sold by 123 Property Owner Group LLC, not the right entity. So do you think that's covered by the owner's policy? It's covered as a forgery. Yeah, it's covered under that same covered risk too, as a forgery, fraud, impersonation type claim. So this is an interesting one. What if someone forges a mortgage cancellation? So in this claim, a guy we'll call Jim inherits a residential property, a very nice residential property from his grandfather. Well, unfortunately, when his grandfather died, he had a very large mortgage on the property. Well, Jim just decides, I shouldn't have to pay that. That's not my loan. That's my grandfather's loan. I don't want to pay that. I'm just going to record a cancellation. So he looks in the land records. He finds, you can look in the land records and find any kind of document signed. He looks in the land records. He finds a cancellation signed by the same bank that has the mortgage on his grandfather's property. And he gets a notary friend to notarize a signature. He just drafts up a cancellation, signs a bank officer that signs all their cancellations, gets his friend to notarize it, records it. Then he goes to sell the property, doesn't mention anything about this, and he takes home all the proceeds of that sale, and the mortgage doesn't get paid. Well, then, a couple months down the road, nobody's paying that mortgage. The buyer of the property gets a foreclosure notice in the mail because that loan's in default. So do you think there's coverage for that? There would be coverage under the owner's policy because it was a prior loan. There would also be coverage under the loan policy because obviously that security deed had priority over the insured mortgage, and that claim, the company actually paid $275,000 to pay off that prior loan. I will tell you, when I handled claims, when I was an outside counsel handling claims, there were several times that I got a panicked call the day before a foreclosure sale under this kind of scenario. Sometimes mortgages that were missed, but we had, in Mississippi where I lived, we had a huge mortgage fraud scheme going where a developer recorded a bunch of cancellations like this that were forged. And I got several calls the day before a foreclosure that a property we insured was about to go into foreclosure from a prior loan. So this does happen.
So when you say mortgage cancellation, is that just like, oh, he died, so we don't have to pay?
Oh, no, it was, he just recorded, if you have a mortgage and you pay it off, the lender records a cancellation so that there's
That's
notice.
where the fraud was.
So that there's notice in the land records that it's been canceled. So he just went in the land records and found a cancellation.
He knew what he was doing.
Yeah, so, it wasn't, but say it was Wells Fargo.
I didn't know if he was making a mistake, like.
Oh, no. He knew what he was, he knew what he was doing. So
Okay.
say it was a Wells Fargo loan. He just searched in the land records until he found a Wells Fargo cancellation.
Yeah.
And he just copied it, and he signed the same bank officer's name that would normally sign their
Gotcha.
cancellations, and his friend notarized it, and he recorded it. So when
Wow.
the examiner ran title, it looked like there was no mortgage on the property because it was canceled.
Wonder, if the notary would be liable for that as
Or
well.
yeah, they would be.
Lose their.
Yeah, the notary would be in trouble
Right.
too.
Notaries.
And that's also a good practice pointer. We always tell people a red flag is a cancellation like that that's close to a closing.
Gotcha.
Most people, not everybody, but most people, if they have a mortgage on their house, they don't just pay it off. I mean, you're paying it because you're refinancing.
It'd be great.
It'd be great if, yeah, exactly, me too. But you're normally paying it in a refinance, or you're paying it because you're selling the property. So anytime there's a cancellation, close in time with no refinance, nothing like that, that's kind of a red flag. That it's not always, but it's just potential mortgage fraud. Similar scenario. So what happens if payoffs on properties get mixed up? So this was the case of 4115 Washington Street versus 4151 Washington Street. So in this one, the closing attorney was handling a refinance closing, and his client was actually the mortgage broker. So he was kind of dealing directly with the mortgage broker for the refinance, not necessarily the owner themselves. But the borrower was an investor, and he had gone in and rehabbed multiple properties in the same subdivision. So the same investor owned 4115 Washington and 4151 Washington. Well, the mortgage broker, which this is also a practice pointer we'll talk about for a second, but the mortgage broker went and got the payoff for the borrower for the property at 4151 Washington Street. Well, the problem was the refinance was on 4115. So the closing attorney gets the payoff for 4151. I'm gonna mix the numbers up. 4151. They do the refinance. He sends the payoff money on 4151, and the bank cancels the loan on 4151. But now there's two loans on 4115 because 4115 never got paid off, and now there's a new loan on it. Well, same kind of thing. It came to light when the lender went into foreclosure on 4115, the one with the refinance. Luckily, it was all the same lender, and so they were able to sit down with the mortgage broker, the borrower, and the lender and say, look, this was a mistake. The lender transferred the funds to, they worked it out on their books, and it didn't actually go into foreclosure, but it could have been disastrous if it were two different lenders. And that's a good practice pointer too. You always want to get a payoff. If you're the one responsible for ordering payoffs, you always get it directly from the bank. You don't ever take it from the borrower or the seller or even a mortgage broker. Not because there's necessarily fraud involved, because in this one it really wasn't fraud. And then the investor just came to closing and signed. He didn't realize there was anything happening. There was nothing fraudulent happening. It was just a typo and just a mistake. But you always want to get your payoff directly from the bank so that these kind of things don't happen. So, and again, I didn't explain, but that would have been covered by Covered Risk 10, which insures against loss or damage incurred by reason of lack of priority of the lien, because that was the problem. The prior mortgage was ahead of the lender on the 4115. One other question I always like to talk about a little bit is, why do you need to buy an owner's policy? Because I promise you, if you handle any real estate transactions, you're going to have a buyer say, why do I need to buy a title insurance policy? It costs more money, and I'm already buying one because if there's a loan involved, the lender's going to require a loan policy, and the buyer will say, well, I'm already buying one from the lender and I have coverage from the lender anyway, so why do I need to buy my own owner's policy? And one thing we've looked at today was a number of examples of things that can go wrong that if there's not a loan, you don't have any coverage for, you don't have any protection for. So I like to just give people a couple talking points, just a little explanation about why title insurance is important for the owner and for the buyer too, and just some things to kind of think about. So your loan policy, if you have a loan and your lender has a policy, it's in place up to the amount of that loan. So as you pay your loan down, that loan policy coverage goes down. And it makes sense because the lender's out, $200,000. Well, as you pay your mortgage down to $100,000, they're only out $100,000. So they only have coverage for that amount. So your loan policy keeps going down as you pay off your loan. And once your loan's paid off, the loan policy's gone. There's no reason the lender doesn't need it anymore. They've been made whole by your payments. So it's important to remember that that loan policy only covers the buyer up to the amount of their loan. Because there are some things that a loan policy would step in and cover for you that we've talked about, but that's only if you have your loan in place. If you're lucky enough to pay off your mortgage, your loan policy's gone. And similarly, it doesn't cover any equity that you have. And same thing. So if if your house is worth $400,000, you pay $400,000 for it, your loan is $200,000. if you're trying to just piggyback on your loan policy coverage, you only have it for $200,000. You don't have coverage for all the equity you have in it. And so if you were to have a total failure of title and lose your house, that loan policy is going to pay off your $200,000 loan, but it's not going to pay you anything for the difference. So it's important to remember the difference in the coverages and the coverage amounts under an owner's policy and a loan policy. It also protects your largest investment, you know, again, and it's protecting the equity. I mean, we insure our cars, we insure our houses, a lot of people insure their pets. So why would you not insure title to your house? That's your house is your biggest investment. And so for a lot of the reasons that we looked at today, you want to buy insurance to cover it. And you know, sometimes people say, well, it's just an investment property. I don't live in it. It's just I mean, I don't need to buy an owner's policy for an investment property. Still the same thing. Right. You're protecting your equity. You've still paid money for it, whether you're living in it or someone else is. You're still protecting your equity. And then the final kind of talking point I always say is, it's a one-time premium. You know, you pay to insure your car, and you pay a monthly or quarterly, however you pay your car insurance. You pay for that regularly to insure you against the future risk. But the title insurance is really, in the grand scheme of things, a cheap thing. And we have, and I won't go into the whole calculation, but there's a simultaneous issue too. So if you're y'all may have already talked about that. So if you're closing and you're buying a loan policy anyway, it's not that much more to buy. You're not paying full price for both. So if you're buying a loan policy especially, it's not much more to just buy an owner's policy. So that is all I have. But